July 17, 2012. This is Justice Dunn, Chief. It's going to give part 2 of the reading of the Attorney General's policy regarding public prosecutions. I'm going to pick up where we left off, which was the decision to prosecute. And what's important about this is the context by which the Crown Prosecutor's Office will prosecute allegations of criminal conduct. Now what's interesting is the decision to prosecute section reads, on completion of the investigation, if the police are satisfied that there is sufficient evidence to lay in information, they will formulate a charge or charges based on their assessment of the case and then forward a full report of the court briefed to the appropriate Crown Prosecutor's Office for pre-charge review. Pre-charge review by a Crown Prosecutor. This pre-charge review involves the application of the evidence test and the public interest test. This process includes an assessment of the proposed charge and the determination of any procedural issues. It must be noted that the evidential test and the public interest test are essential considerations in the decision to prosecute that must be applied by Crown Prosecutors on behalf of the Attorney General. The first consideration is the evidential test. If the case does not pass the evidential test, it cannot proceed further, no matter how important or serious it may be. The second consideration just turning the page here, excuse me. Second consideration is the public interest test. Crown prosecutors will only agree to prosecution when the case has passed both tests, which are further explained below. So the evidential test. Crown prosecutors must be satisfied that there is evidence to provide a reasonable prospect of conviction against each alleged offender on each charge. A reasonable prospect of conviction is an objective test. It means that an impartial trier of fact, example, a judge or jury properly directed in accordance with the law, is more likely than not to convict on the offense charged. When deciding if there is evidence to prosecute, Crown prosecutors will consider whether the evidence can be used and is reliable. They will also consider They will also consider what the defense case may consist of and how it is likely to affect the prosecution's case. There will be many cases in which the evidence does not give any cause for concern. However, there will also be cases in which the evidence may not be as strong as it first appears. Crown prosecutors will always draw on experience to evaluate how strong a case is likely to be when presented in court. Now, public interest test. Having been satisfied the evidence itself can justify proceedings, Crown prosecutors will then consider whether the public interest requires a prosecution. Public interest factors that may affect the decision to prosecute usually depend on the nature of the offense or on the circumstances of the offender or the victim. Some factors may increase the need to prosecute, but others may suggest that another course of action be taken. Crown prosecutors will carefully balance factors for and against prosecution. It follows that the graver of the offense, the less likely that the public interest will support a disposition other than prosecution. The following list of some common public interest factors, both for and against the prosecution, are not exhaustive. The application of relevant factors will depend on the facts in each case. A decision based on the public interest test is not simply a matter of adding up the number of factors on each side. Crown prosecutors must decide how important each factor is in the circumstances of each case and go on to make an overall assessment. So these are factors that support prosecution. The following factors support a prosecution. The offense is serious and with conviction likely to result in a significant sentence. A weapon was used or violence was threatened or used during the commission of the offense. The offense was premeditated. The offense was committed against a public official. The alleged offender committed the offense while under an order of the court. The alleged offender was in a position of authority or trust. The offense was carried out by a group. The alleged offender was a ringleader or an organizer of the offense. There is a marked difference between the actual and mental age of the alleged offender and the victim. The victim of the offense was vulnerable, has been put in considerable fear, or suffered personal attack, damage, or disturbance. The offense was motivated by a form of discrimination against the victim's ethnic or national origin, gender, religious beliefs, political views, or sexual orientation. A successful prosecution facilitates entitlement of the state or the other person to compensation, reparation, or forfeiture. The previous convictions of the alleged offender are relevant to the present offense. There are grounds for believing that the offense is likely to be continued or repeated, for example, a history of recurring conduct. Although not serious in itself, the offense is widespread in the area where it was committed, and the necessity to maintain public confidence in government, courts, and the administration of justice. Now we'll move on to factors that do not, I repeat, do not support prosecution. The offense is trivial or of a technical nature and would likely result in an imposition by the court of a very small or nominal penalty. The consequences of conviction would be unduly harsh in relation to the seriousness of the offense. The loss or harm can be described as minor and was the result of a single incident, particularly if it was caused by misjudgment. We'll continue on. A prosecution is likely to have an adverse effect on the victim's physical or mental health, the advanced age or ill health of the alleged offender, the degree of culpability of the alleged offender is slight, the likely length and expense of trial, the law is outdated and impossible to enforce on an equitable basis, the likely adverse effects of prosecution on public order and morals, or there has been a long delay between the offense taking place and the time of the charging decision, unless the offense is serious and the delay has caused in part by the offender, the offense has only recently come to light, or the complexity of the offense has resulted in a lengthy investigation, and details may be made public that could harm sources of information, international relations, or national security. Alright, then we'll move on to factors that cannot be considered by the Crown. The following factors should not be considered in a prosecution. The Crown Prosecutor's personal feelings concerning the ethnic or national origin, gender, religious beliefs, sexual orientation, or political views or association of the alleged offender or the victim. The Crown Prosecutor's personal or professional relationship with the counsel for the alleged offender, any partisan political advantage or disadvantage which might flow from the decision, the possible adverse effects of the personal or professional circumstances of those responsible for the charging decision, and any known or preconceived views held by the judge who is expected to hear the case. The next section is called Assessment of the Charge. The charging policy is such that the most appropriate charges will be chosen to reflect the circumstances of the case. Two or more charges should not be laid relating to one act for the sole purpose of being able to negotiate a guilty plea. The next section is Crown Election, dual procedure offenses, summary conviction, or by indictment. It reads, in dual procedure offenses, Crown prosecutors should proceed by summary conviction in the absence of reason that warrant proceeding by indictment. Reason for proceeding by indictment includes serious factual circumstances as well as situations where an offender has a lengthy criminal record or has repeated the offense. Crown prosecutors should not proceed by indictment solely in order to overcome the summary conviction limitation period. Proceedings by indictment in order to overcome a tiny limitation may be appropriate in the following circumstances. The offense was not disclosed or the alleged offender was not identified in time for a complete investigation before the expiration of the limitation period. The investigative agency acted with due diligence, but the investigation continued beyond the limitation period because of the complexity of the case. And finally, the alleged offender contributed significantly to the delay. Alright, so that's the part 2 the video series that's regarding Attorney General's policy regarding public prosecutions, and that was specifically regarding the decision to prosecute. If you're ever wondering why Crown Prosecutor's Office takes a case or doesn't, what I just read was what should be factored into that decision. So that's it for now. It's part 2 of this video series. Thanks for watching. It's July 17, 2012. This is Justin Dunder Cheap, Fredericton, New Brunswick, Canada. Thanks for watching.